All right. So, hey everybody. Hey to our audience. Hi, Colin. This is our August of 2026 uh episode, and as always, not as always, but as of lately, we're continuing to talk about AI stuff. Here we're going to talk about productivity tools, about hiring, sort of like how AI is actually landing in ways that are being used and becoming foundational in our organization, because we shouldn't let things become foundational without understanding the role that they play in the foundation. And again, AI is just sort of everywhere. Um, thanks, Sarah. I saw your text saying I remembered to record for the first time. Um, Thank you, Sarah. Thanks for
I was
celebrating.
telling Mary Beth so she would be comforted.
Yeah,
All
she
right.
celebrated. Like,
So we're talking about AI. Everybody's so afraid of the regulatory scheme with AI, and I can confirm you should be scared of the regulatory scheme. I got another email yesterday about the way a expert witness was just lambasted in court because, or actually I think it was in a deposition, about the way he had engaged with his AI to prepare for his deposition. And they went and took all the prompts, and the prompt said something like, help me get me to 100% proving that the other side is wrong, which is not objective or third party, right? But like it came back on the party that hired him. And the same thing happened when we're in HR or in operations or the receptionist, and we are engaging with AI in ways that make it just so clear that we are not appropriately evaluating or handling things. And in this particular episode, I think we're largely going to focus on evaluations. It is a recurring theme as I look through. Well, here are the everyday workplace tools for AI. Places that we do or do not appropriately spend time evaluating things is a bit of a recurring theme in here. So, a couple of regulatory flags. The EEOC, we don't know what they think. Nobody ever knows what they think the last couple of years. There was a bunch of guidance that came out under the last administration that talked about AI. Of course, it talked about AI 2 years ago. But at the time, it was contemporaneous and the best we had. And most of the EEOC guidance came down under the current administration. So a lot of employment lawyers are very much and the new guidance was put out, but put out in some questionable ways in many places, and other places it just kind of went back to the way things always were. But as it relates to AI, we don't quite know what the EEOC, what the DOJ are really thinking as far as the way AI should be and is landing with organizations. There is a DOJ opinion on Title VII about disparate impact. And that's interesting because it doesn't change the case law that exists. And so I know that we're still at least talking about it. And what we do with it in decision making is all complicated now, but we're definitely still talking about it. Colorado has SB 26189 that talks about narrowing the transparency efforts of AI in hiring in particular, and in other activities that employers and organizations do. New York state law has, and Illinois does too, has some rules around disclosing some hiring activities. But the one everybody knows is still that Mobley v. Workday, where uh, an employer got called out for using a tool, not a tool they developed, but for using a tool that had some undisclosed bias written into it. And, we are still talking about it. That case is probably still percolating just a touch, but it exists. So with all that being said, let's do a real quick roundtable of who everybody is. Um, Amber, Brian, Lindsay, Sarah, maybe we can go in that order. Nobody needed to remember that. But I'm Natalie Lynch. I'm the founder of Trady Oak. When my real expertise is hiring people that are smarter than me, and which is why I bring them to you guys in the Zoom every month in our Acorns. And we hope that you guys think this is really valuable. Will continue to join us. Amber, you want to tell us who you are?
Sure. I'm Amber Howard, and I'm a HR consultant, and I've spent my career working across the full employee life cycle. And so just helping organizations on HR needs.
All right, Brian, who are you?
Hi, I'm Brian Levy. I handle the firm's litigation. So generally, it comes to me whenever there's an opposing party, and my style of practice is realistic and laid back. I think that we can usually solve our problems better than the courts can. So, you know, just because you have a problem doesn't mean we can't make it go away.
All right, so we got Amber on prevention, Brian on resolution. Lindsay, what do you do for us? Dr. Lee.
Um, Dr. Lindsay Lee. I am an organizational psychologist, and I work on the investigation side of the house and also provide executive coaching services. And so, Brian, as you were talking, I just have to comment, like, as our litigator, you spend most of your time trying to figure out how to not litigate.
As any good litigator does. Sarah, what about you, former litigator lady?
Yeah, so I decided I didn't really like court. So I ended up going to the transactional side. I do tax informed business formations, business structure analysis, all things contracts, fractional general counsel type services. And yeah, just a one-stop shop for your business needs. Can go all the way from like entrepreneurship and like business plans to how your estate plan should match what businesses you're building.
And so watch this audience as we have an employment conversation and it keeps coming back to the stuff Sarah deals with every day. I also just got back from a conference where one of the big themes was all the attorneys in the room were like, I'm so sick of arguing with robots. So all right, let's kick this off. Brian, what what are our clients, what are our employers doing to create liability? AI tools, they're screening resumes, screening responses, and they're bringing us candidates. So at the very foundation, the input within, bringing in talent just from the beginning, we have AI at the very insertion of our engagement with humans through our clients anyway. Does it matter if the employer built the tool that they're using that may or may not have implicit bias in it?
It really doesn't matter who built the tool. Outsourcing the screening of your employees, it can't be outsourced. So just because you hire a company or you hire a tool, you let AI do it, you're still on the hook. There's no the algorithm did it defense when you're talking about employment law. And the concept, this is an original concept of employment law. It's disparate impact. So even if you didn't intend to discriminate, if your tool screens out every white guy or every Native American woman, you are still discriminating under the law. And you can't say, it wasn't me, it was my algorithm. That just does not work. And in a recent court case, they're even bringing in vendors to be held liable under the discrimination law. So in that case, you're going to be arguing with one of your vendors of whose fault it was, not you're going to be getting out of it. So the bottom line here is outsourcing the screening does not outsource the liability.
Yeah, I think that's right. And it's hard. Like, let's say you're a little artsy fartsy company and you go hire a big tech tool, and you may not have the skills to evaluate the contract, much less the technology that you're using. I mean, it's kind of terrifying. Lindsay, from a testing and measuring standpoint, this is going to come in when we're writing the screening questions, when we're evaluating things, when we're having people do testing and screening, on a test before they get in. I know one of the things that I've learned over the years is how infrequently any of those testing protocols or schemes are peer reviewed. It's just somebody had a concept and rolled out a test, and they don't get a lot of peer review. And that's one of the things that I have taken from my time with you, to go back and engage with clients. But what should have happened before we pick a tool, and how does it actually happen when our clients pick a tool to do hiring and screening activities?
It's a great question, Natalie. Regardless of what tool you're using in your screening, evaluation, and hiring process, even in the recruitment phase, actually, it's an employer's responsibility to demonstrate that tool is predictive of something that's important for the job. And we call that validation in my world. And so as the employer, we're talking about AI today, but really it's no different than any other screening tool that you would use in the hiring process. You have, as the employer, have to be able to demonstrate that that tool tells you something important about how good they're going to do the job. And we call that validation in my world. And so to Brian's point, though, the underlying piece of that is you also have to conduct an analysis to demonstrate that it's not producing adverse impact. And that's across the spectrum of protected classes. So race, age, sex, disability status. If your tool, even if it's been validated, reliably screens out certain groups of people that are protected by law, you have a problem, and you need to know that in advance.
And I think anybody that's taken Employment Law 101 at least knows the concept of the story about the firefighters. And like we had all these robust tools and they just happened to screen out all the black candidates. And it had nothing to do with saving lives and fighting fires. And so that's kind of become the poster child for this. And I think people forget that that happens regularly with these screening tools for people who are desk jockeys, for people who are programmers, for people who are receptionists. If you're asking questions about credit worthiness for somebody who is an artist at your organization, like those two things are not related. And if you're screening out classes of people, it's not even legal. It's a bad practice. It's going to lead to bad hiring. It's going to lead to really bad culture, but it's also illegal. Um, it really does land even with our non-firefighting clients, although we do love our firefighters clients too. Um, there are some of the fun ones. All right. Thank you, Lindsay. Let's, Brian, move back to you just a little bit. And by the way, I didn't say this at the beginning and I should have, but attendees, if you have a question, I'm usually good enough to catch it if you put it in chat. But you can also raise hands and I can usually catch it at certain points. So feel free to chime in. And then also, obviously, my team knows that my team's really good at interrupting me. So I'll encourage my team to continue doing that thing they do anyway. All right, Brian, we're going to go back to you. But Lindsay, I think you might have something to say about this one too. If a company already has one of these tools live today, so a hiring tool live, some of the tools that people use just for general AI also have a hiring, portal or program associated with the add-on tool. But so if we have one live today, what's the fastest way to find out if there's a problem before somebody else finds out in a less safe way? So how can we find out if our hiring tools have bias built into them if we already have them deployed?
Yeah, you should run some practice simulations, but before you do that, you might want to hire counsel to run those practice simulations for you. And I'll tell you why. Because if your lawyer does it, it is not admissible. Whereas if you go testing and find something, then you get sued later. It might be the exhibit 1A of your demise because you ran the testing yourself and you didn't hire an attorney to do it. So please do it, but also please remember that is admissible evidence.
Yes, that's the thing we keep talking to our clients about. Lindsay, I'll punt to you, but I bet every single person on this call, maybe to include all of the attendees, I bet, we keep having this call, and I even keep having it on the sales side. Like before these people are clients, I'm like, hi, I can tell that you engage with AI about the questions you're asking me right now. Please stop. None of this is admissible until we're engaged and we're doing the questioning. So please stop. Every single thing you're doing is admissible. Lindsay, what are you thinking about this? I do feel like I'm taking tools away from people, but it's not good.
Yeah, at the risk of persistently banging the drum on prevention, I'll just echo what Brian said, and that is like run your analysis now before some plaintiff's attorney wants to get a hold of that data. And you can simulate it. If you don't have enough volume of hiring, you can use, there are statistical analysis tools out there that you or your attorney can use to sample your actual hiring data and model it over multiple iterations. And so run that analysis now. The Uniform Guidelines on Employee Selection Procedures, which were published in 1978, are still the guidelines that we're using. And they refer to what's called the 4/5 rule as a guideline for determining whether or not your selection procedures, to include any AI screening tools you're using, reduce adverse impact or disparate impact. And so we can't get into the weeds here on how to do that analysis, but the uniform guidelines would give you and your attorney good guidance on that. But my takeaway in this regard is do it now before you get sued over it.
Yeah, Amber, hey, I'm gonna come at you. And you didn't know I was gonna do this, but now I am giving you 12 seconds of heads up. We haven't, you're our HR guru, and we haven't talked to you all at all. What are you seeing on the ground with the way people are hiring lately and the way they're using AI tools, either homespun AI tools or the bigger hiring tools? What are you seeing on the ground about the way people are really, real people are really engaging with these tools or not?
I think recruitment is the biggest one. We've said on that a lot, but overall, I think it's become widespread in every aspect of the employment life cycle. And so it's just not in recruiting. So it can be screening, ranking resumes, matching candidates to jobs, scheduling interviews, helping summarize interview feedback. And then you move from there into onboarding. It can be answering employee questions, personalized training, recommending content. Once they're employed, just day-to-day HR operations, scheduling, workforce planning, engagement surveys, trends in employment data. But I think the biggest one is performance management. It helps summarize feedback, identify themes, drafting a lot of reviews or documents, performance trends. And I think that's where a lot of employers should really pay attention because those are what really influence the decisions about compensation, promotions, discipline, and development. So, and then at the end of the employee life cycle, to kind of round it out, it can be used to summarize exit interview feedback. And so I think the bigger question is where does AI not touch within the employee life cycle? And what information are you using? And is it influencing employment decisions that you're not even really realizing?
So true. And I'd wind back. Natalie didn't ask for this, but one of the I don't even know if this is a newer trend. I think it's been going on for the last couple of years, but I remember a conference I attended. People were talking about the future of hiring involving AI robot interviewers as like to conduct initial screenings. So you kind of hopped right over that, Amber, as a way that AI is being used in the hiring process. And employees, candidates are increasingly talking publicly about their experience with these AI interviewers. And of course, they're better now than they've ever been, but really taking a close look at how those AI robots are conducting those screenings and screening them out, because people who are highly qualified are getting screened out through the use of these tools, and it doesn't serve the candidates certainly, and it doesn't serve employers to because oftentimes what we hear from our clients is things like, well, I didn't get any good candidates, or nobody wants to work, or I've had this job posting out for 6 months, and the ones that are coming to me are not qualified. And a lot of times it's because they didn't adequately prepare the AI tools that they're using to give them the kinds of candidates that they need.
Well, I'm gonna do what you just did to me back at you, Lindsay. You and I had an experience with a situation where a candidate showed up and we do not think we were, and I've heard other, like, this is a big deal too, like candidates that show up on video
Yeah, if you're
calls
doing
are not the ones that show
video
up for the
interviews.
first day of work. But you and I had an experience where we don't think we were interviewing somebody. She had headsets on and somebody else was giving her,
Or
some
something
robot,
else. Yeah.
was providing answers to her. And it took 2 interviews actually till we interviewed. Like, she was really good at it. But it did occur to us that she was not the one providing us answers.
Yeah.
And so that,
Works both ways.
yeah, it does work both ways. We attend these conferences with these major employers. They are having gigantic problems with interviewing a great candidate and it being wholly disconnected from the person that shows up for the first day of work. It
Yeah.
goes both ways.
Yeah.
All right. You did this to me. Now I've lost track.
I'm sorry.
But hey, Lindsay, I think we were back at you. What happens to a manager's judgment? There's so much of AI that it's like, okay, we'll give you the answer, we'll give you the answer, we'll give you the answer, but you should totally go use your human judgment on top of this. So what happens, Lindsay, to a manager's judgment? And maybe Amber, you can chime in on this too, because you deal with the consequences of those managers having or not having judgment here. But um, the mechanism for doing this is getting lost. Managers aren't getting an opportunity to put human judgment on top of this in some cases. What do you think about that?
I don't think it's that they don't have the opportunity. I think they've been lulled into trusting dashboards, metrics that look very objective. And Amber kind of moved the conversation toward performance management. And that's how I'm thinking about this problem. We get all this data now that looks objective, it looks legitimate, it looks like it's measuring something real. And but just by human nature, get really lulled into having, red to green dashboards in front of us, or numbers or metrics in front of us, as if that's something meaningful, without bringing all of our own expertise, our own contextual knowledge, our own institutional knowledge. And to the extent that you aren't bringing those things to the decision making part of the process, you as a manager are really putting your organization at risk and putting yourself at risk for not being able to defend a decision that wasn't made by human judgment. And so we have to really remind our managers that while we have these very rich, efficient tools for helping us get information about how our employees are doing, we cannot skip the step of overlaying that information and that data with our own judgment and our own expertise.
Mm-hmm.
It's not always right. It's not always right.
Amber, what do you think?
I think managers sometimes are so busy and they have so many things going on, and personnel issues are sometimes the last things they have time for or want to deal with. And so they put some context sometimes into AI. And so I think just making sure they have all of that context instead of being very quick, because it might be one situation, if we're going back to performance or whatever it may be, one situation, and then there might be a history, or there might be something they didn't know, or just making sure that you take the time, because AI is instant sometimes. And you're like, okay, great, there's the answer. I can do this. And you don't even think to process or make sure you've typed in all of that information. So I think just really taking time to be cognizant about that.
All right, I'm gonna go totally off script. Sarah, we see this come up in people putting together partnerships. It's not just an employer bringing on an employee. We see people doing the same thing in partnerships. Like, hey, can you write us the agreement for us to do a deal together? Are we, are the two of us even simpaticos? Like, can we keep going here? And AI, yeah, no, absolutely, or absolutely not. You two are awful, and it's disconnected from reality, right?
Yeah, oftentimes whenever I've seen a lot of AI interactions with my clients lately, and they either won't give it the proper context, so AI spits out interesting solutions, or it's trying, they're not it, but the client's trying to hedge on like a controversial opinion, so to speak. So like in the tax law world, you have a lot of controversial tax opinions, things like that. Because from a tax attorney perspective, it's always show me in the statute where it says I can't do it. Well, that can work in the tax context, but when you go to local regulatory boards, it doesn't work out as well. And then you end up getting hit with fines and interesting things like that. And people act surprised, but the people pleasing nature of AI, even if there's no like local regulatory decisions or there's no support for it, it's like, yeah, okay, you can do this because nothing tells you no. And it will apply the wrong perspective to different fields of law. And it can also just spit out company agreements and dynamics that end up costing a lot of money down the road in legal fees, because it works in things like, unanimous decision making mandates for like minority owners, and just takes out all the protections that if you actually have a conversation with your attorney, they'd be like, okay, tell me a bit about the dynamic, what kind of working relationship you think you guys are going to have. What would you like to do if they change? Like they don't get in sweat equity. They said they originally would. And it's just, you need you need to have that conversation and not just give it context that you think's important, because it's hard to know unless you've seen it every day and you see how things blow up, what you need to know.
I mean, at the end of the day, I think we're talking about using AI to go do peopling things, and the end result is people peopling. And so I think we are so far off from being able to completely abdicate our obligations to put like people together. All right. So I guess on that, Amber, I'll go back to you about this continued concept we have of maintaining human oversight to things. Um, we have used AI to help expedite the creation of policies. What does an AI policy about AI have to tell us anymore?
Yeah, I think, that maintaining human oversight, it sounds easy, but I think we have a lot of clients that come to us and they love to start a first draft from AI, which I think is great. However, AI sometimes flags things that aren't really issues or making a mountain out of a molehill on certain things or doesn't flag things that should be an issue. So I think while that's a great start, I mean, I can go through something that looks great on paper, it's formatted wonderfully, and it's, 6 pages and it's got everything, right? And you're flagging things just from, that experience or, what to watch out for that company specifically, because we really try to, get to know our companies. So, um, again, I think you're like, well, I'm human, I'm looking at it, but coming back to whoever is, a subject matter expert in that area to really review it and be able to identify things that could be a red flag or a yellow flag.
Hey, Brian, you want to throw in any comments about clients running up their bills because they trust their robots better than their Brian?
Well, I think AI can be a great thought partner. And we have internal dialogues about a problem. I'll ask Amber or Sarah or Lindsay or you, Natalie, and we'll go back and forth like, well, what about this? What about that? AI can be good at doing that, but only if you know the right questions to ask and you know when to say you're just wrong. And sometimes that doesn't happen. But also, I think what Natalie was talking about is we have clients that kind of take every email we send and run it through AI and say, what question should I ask? And that's just really um it might be helpful for having a dialogue. If you wanted to have something to say back to somebody, they will give you things to talk about, but they're just not relevant things. And most of the time, it's running the bill up to get backwards of where we need to be. And it just doesn't add to the flavor of what we're discussing. And so I think knowing when to use AI is part of the when, and the other part is knowing what to ask.
Yeah, I just sort of, I'll give two ancillary examples. Like this isn't just the employment dynamic where this is coming up. I'm coming to realize after a handful of exposures and engagements, being in rooms with a lot of attorneys, that people are moving away from flat fee structure within their law firms in the instance that a client uses AI to engage with them. They cannot predict the ridiculousness that will come out of a legal activity where the client insists on using AI, and so they simply refuse to do flat rate, which is been a thing over the years that bars and business consultants have encouraged law firms to do to get really, really efficient at all of the things about being a lawyer that are routine. Because it's access to justice, right? Like you can afford a better lawyer better if the lawyer is being really smart about their business practices. Well, lawyers can't be smart about business practices if we're arguing with robots 90% of the time. And so people are saying we are having to, in the interest of staying in business as lawyers, we're having to abandon flat rate fees for anyone who won't agree to not make us argue with robots. Um, and that's bad. And so in my actual landed example, I still do a lot of our most of our intake and of new clients into the firms, which is one of my favorite things, you guys. But a lot of those rep agreements go out and they come back with AI feedback. It's gotten so consistent that I have even some somewhat canned verbiage where I'm like, oh yeah, AI hates attorney representation agreements. And if you think about it, it makes sense. Nobody's using their Claude credits if Claude is answering all their legal questions. Of course, they're going to tell you it's a bad idea to hire a lawyer. Of course, they're going to tell you that your lawyer's rep agreement is awful. And I get the exact same feedback from Claude and the exact same feedback from ChatGPT. Like I can tell you which AI you threw my rep agreement into these days. But the responses are so consistent, like you don't need to hire a law firm, and even if your AI doesn't say that, it picks at some really consistent things. And honestly, some of the stuff it's picking at is so I'll have clients come back to me and demand that I change things in ways that are completely unethical. Like I could not keep my license if I did what AI is asking them to ask me to do. Hey Brian, what's up?
And by the way, when you just ran your problem through the AI chatbot, you just created a record that is discoverable.
Yeah.
So the very problem you were trying to hire a lawyer to fix, you've now encapsulated that perfectly for opposing counsel to throw right back in your face.
Right.
So
Like, hey, my employee is acting crazy. I'm gonna hire this law firm. What do you think about their rep agreement? Now that exact engagement is a pre-representation engagement where you said your employee was crazy and you had bias about their mental health in the workplace. Um, I mean, it's bad. All right, let's get back
Right.
on
Oh,
agenda.
real quick, I was just gonna add, it reminds me, like, I feel like clients have gotten increasingly better about not putting smoking gun statements in email correspondence. Like that is becoming less of a,
Right.
they don't think about AI as like the same, they need to avoid the same thing in their AI conversations as well. And it is just a fact
Said differently, Lindsay, clients still know when to pick up the phone and call us. They
versus
don't
put
know
it
when
in
to
an
pick up
email.
the phone and call us versus talking to AI. And
Right.
I don't, when you think about it that way, I don't quite get the disconnect. But
Right.
I
Right.
think culturally as a people, we'll get there. But in the meantime, yikes.
Stop creating discoverable records that you don't want to be discoverable.
Only create the records that Amber tells you to create that are intentionally discoverable because they're just so good. All right, let's move over. Brian, I'm going to come back to you. AI note takers on our on investigation. So, Lindsay and I talk about this. We talk to AWI about this. We always want to stay on top of the best practices for investigations. But what happens to privilege and what happens to that transcript if, for example, somebody like Lindsay and I used a note taker to do our notes for an investigation?
sure, that transcript now becomes discoverable, and because you involved a third party, there is no privilege. Um, to to explain privilege on the basic level, if you are talking to your attorney, that is a privileged conversation. If you and your assistant are talking to the attorney, that conversation is no longer privileged because there is a third party there that breaks the privilege. So the same goes with respect to AI note takers. And you've now probably just made that transcript property of the AI company as well. So, if you want to have your data training people's robots, you can do that, but please don't do it when you're having an investigation.
Yeah, training your competitors' notebooks. And Lindsay, I will get to you because I know you and I have some thoughts on things
All
on
things
this.
on
But hey,
it.
Amber, what's protocol for AI tools before we even get onto a call or in the room with an interviewee?
I think just checking the technology. So turning off AI note takers, transcriptions, recordings, meeting summaries, anything that's automatically going to capture or generate content. So, sometimes it's at the org level, sometimes you don't realize. So just also being cognizant beforehand of maybe now going out and saying, okay, what do we have running? Is Fireflies automatically coming on there? Is this, whatever technology that your organization or yourself may use. And then who's in the meeting? Do they have a note taker as well? Because even if yours is off, is theirs on? Um, And then decide how you're actually going to document the interview because a lot of times we rely on these wonderful technologies. So just making sure you have kind of a backup plan for that. And then I think the last thing is really making sure if managers are doing any of these or if it's not you specifically, training and knowing, having people know what HR technology the organization uses, what they can use, having those policies and, when to turn it off, and just making sure that you're cognizant of different situations that could arise from this.
Lindsay, you want to talk through how we handle technology in the room that we may or may not know about as independent third party investigators? How do we handle that in our admonishments?
Yeah, we always nowadays assume we're being recorded, even though in every interview we have a conversation with our interviewees. And this is just kind of demonstrative of what our practice is in our firm. It is still the notion of recording is still kind of a divided issue as it relates to best practices in investigations. Some people always record and they have very good reasons for always recording. Others never record, and that's the position our firm has typically taken. And so the conversation we have with interviewees is really centered around letting them know that we're not recording that interview. And especially, we're doing Zoom mediated interviews most of the time. They would know if the recording was on, but I also assure them that I'm not utilizing any external recording devices either. And we ask them to verbally announce that they are also not recording the conversation. It's usually not an issue to get a verbal confirmation. And I also, to soften the blow for some folks who insist on recording or came to the meeting assuming they could record, I always invite them to take their own notes. I'm going to be taking notes and give them the opportunity to do that. But again, at the end of the day, even despite having the admonishment, despite getting the verbal agreement that they're not recording, we still assume that they're recording their interviews. And so it is kind of an ongoing topic of conversation in our world, given the level of technology that exists around this.
And Lindsay, I'm sorry, everybody, to exclude you, but I'm wondering if Colin's chuckling right now because even way back when we worked with Colin, we were working with, JAG officers and people who had touches into FBI and policing organizations, and we were talking about lapel recorders and pen recorders, even back when we were all professional babies. I mean, this is not a new issue, but the brilliance of the way our industry has come to ask people include those admonishments is that pattern and practice is a legally defensible activity. And so if we ask that in every single interview that we have done for the last 20 years, it would be hard. And Brian, I should probably let you be doing this lecture, but it would be hard for somebody to come in and say, nope, in this one instance, they broke their pattern and practice. They did it for 20 years, but in my client's interview, they didn't do it. Sure, totally, they didn't do it. Um, or when the interviewee said they weren't recording and they actually were, they started the interview with dishonesty. And so we have one or the other of those dynamics. But all of this, Brian, I am going to go to you. I don't know if you have any comments on what Lindsay and I were just chatting about, but what happens when an investigator's notes and transcript notes, however those things came to exist, or exist in a litigator's lap, what happens when the transcript notes and the interviewer's notes are not consistent with each other?
Well, I guess when the transcript, it creates a problem either way. And you don't want to have conflicting accounts because it makes both of them people are probably going to trust the robot more than the person, which is not always the accurate way to do it. And in addition, when you create transcripts and then an employee tells you that they're going to sue, now you're responsible for preserving those transcripts and making sure that they are preserved. So if you don't turn off the auto delete functions, you can get sanctions from the court up to and including your case being dismissed. I think this just happened in one of our cases where the party deleted Slack. They stopped paying their subscription of Slack during after the lawsuit was filed, and they got in big trouble with the court. But the same thing is true of these transcripts. If you have transcripts for every recording except for this one, you're going to look like you did something wrong.
And you should. All right, transactional Sarah, you used to do and worry about the things Brian worried about, but now you're doing a lot of prepping us for vendor contracts and helping your owners and your operators understand what the nature of the words on documents say about how they're going to engage with their vendors. So when a company signs on with an AI vendor, if it's HR related or frankly any other topic, what are contract terms that we should be looking for to make sure they do get included? I know there's some audit expectations that, big firms are mandating, and gosh, it's also overwhelming, but can you help boil it down to what should we be looking for in these click forms or other, otherwise, acquiring services that use AI? What should we be doing?
Yeah, so the big hot button clause lately has been the indemnification provision. So a lot of these bigger companies have been saying, hey, if there's any discriminatory effect, we want you to indemnify us for that. And just trying to work in those protections. But states like Colorado are now saying you can try that, but it's going to be legally void. So I think a common mistake, especially when you have these multinational companies, they have these vendor contracts, they're just so excited to use the tool. And they might negotiate a change and not even look at the context. The vendors, general counsel might be like, well, this is legally void, so we'll go ahead and put it in there. And you're just not as protected. So look at those indemnification provisions before you rely on them, and definitely keep up to date with like the relevant locals law, because local law has been doing a lot of interesting things with AI just because it's such a dynamic area that it's not, hey, this is going to be fine everywhere kind of thing.
All right, we're going to stick with the Sarah show. And you brought up Colorado. What is, I guess, I think maybe you partially answered this question, but I'll invite you to talk any more
Yeah.
about Colorado or any of the other states' laws that are coming up. What's actually changed? What's the deadline that we should be looking at as employers? And what do you think about some of that?
Yeah, so Colorado, they just repealed one of their AI laws, and the new one goes into effect January 1st of 2027. So it's slightly different. It still has teeth, but it's now very focused on what it wants to happen. So under State Bill 26-189, we already talked about the void indemnifications. There's also no private right of action, so consumers cannot sue companies directly under the state bill. That's an update from the old one. And fault allocation is really the big one that came out of this one too. So developers share liability for state anti-discrimination law violations based on relative responsibility. So there's no joint and several liability. You really just need to do the audits like we talked about before and keep things kosher, and don't say, well, the vendor's going to save me. The chances are they will not.
And then Sarah, who's on the hook when something does go wrong?
The employer.
Anything else to
Yeah.
add?
So if the employer uses an AI tool in a discriminatory fashion, like the employer's on the hook, and you can get some
Mhm.
personal liability for the decision makers that were supposed to be monitoring this tool.
Yeah,
So
you can hire a big fancy Sarah to rewrite or to scrutinize your contract, but at the end of the day, you cannot delegate your civil rights. Your obligations to humans under the law, you cannot get rid of your responsibility for civil rights. This comes up all the way through the way that you treat employees from the very beginning, all the way through the termination and after. You can't write contracts around somebody's civil rights. You just can't.
yeah.
All right, I'm going to pause again. Anybody, Sarah, did you or anybody else have anything to add? We're going to do closing fire round and then see if anybody has any questions.
Nothing bad for me.
Y'all are never quiet. What's this? All right, Brian, what kind of audit should everybody run this month?
I mean, you should audit all of your technology, but especially your AI. and have an AI policy. We'd be happy to help you out, or maybe you could ask AI what your AI policy should be, but we wouldn't necessarily recommend that.
All right,
I guess I'll do it.
I'm gonna bring in the name of Sarah because I'm gonna be sitting in a room with Sarah next month. I'm so excited. I'm doing this, but Amber, what's the one workflow that Sarah and I or any of our listeners should do and work on this month?
I would say check the manager to HR decision workflow. So, one common employee decision, whether it is discipline, leave, promotions, and just kind of walk through it from the beginning to the end, and see where AI is being used and how you can kind of what the human oversight is of that.
All right, Lindsay, what's one conversation that we should have with our human managers?
Yeah, so your organization needs to be able to explain that humans are making the decisions in your organization. And you can't do that if you don't know what your managers are doing with the AI tools you've given them. So it's a good time to remind them how you expect them to use the tools. And this probably goes back to policy that Brian just discussed. And so talk with them about how often are they using your tools? How explicitly are they using them to facilitate decisions? How often are they applying their own knowledge and expertise and making adjustments? It's a red flag for you if they aren't applying their own judgment processes to the tools before they're making decisions.
Okay, Sarah, my question to you is if I want to spot check my contracts, what's one clause I should be looking for? What are some maybe keywords I could search for to get to clauses I should be auditing this month?
Indemnification's a big one. And then data policies and intellectual property rights. So yeah, that's three for you.
What should I be looking for within that? Kind of,
One, make sure that it's trying indemnification is actually giving you protections that aren't legally void in your jurisdiction and that help you in a way that you can plan around. For intellectual property policies, it's hard to get these in actual vendor contracts. Sometimes vendor contracts have went rogue and do some interesting things. So it's just worth searching intellectual property IP just to see what's going on. And make sure you have internal policy so people know don't put like the company's secret sauce in open source AI and then get surprised whenever it gets leaked out, but people keep doing it. Yeah.
All right, I moved a
Don't
handful
sign
of,
things you don't read. There you
yeah,
go. That's my big takeaway. Still
right?
happens.
Yeah, it does. I moved a handful of the attendees over to being able to engage with us. Anybody have any other questions? Any of my team? You guys have any thoughts or last minute things? Maybe a storytelling? Amber, I thought you were going to raise your hand, and I was so surprised.
If you don't
Uh,
protect your trade secrets, a court's not going to protect them for you. So, as Sarah was just mentioning, please don't put your super important trade secrets into the AIs.
yeah. Yep. All right. Any questions from the audience? Otherwise, we can give everybody the last 7 minutes of their lunch back.
Hey, well, guys, I've got a thought. This is a great conversation, by the way. Thank you. I work for a company that provides Title IX and civil rights investigations to colleges and universities, and we are very curious about appropriate ways to include AI in our work, but we've we have held off for some of the reasons that you've already described. We are not willing to put our information or our clients' information into these AI engines and then make it available to whoever owns these companies. But at the same time, we recognize that there are probably some useful applications for this if it were secure, but we don't trust that security yet. Do you have any recommendations for ways to actually use it in investigative work that would keep it out of the bad robots' hands?
So there's a couple of things, Lindsay, of course, I invite you to also participate. One of the things you didn't say, Colin, but sometimes people in universities are actually still children. And so that's also scary and interesting. And this is the biggest topic in the Association of Workplace Investigators, and it has been for years. So I don't think there is an appropriate answer. Obviously, the clients that you're working for probably have something to say about this, Colin, but a couple of things that come to mind. you can do you can do anonymizing things to your engagement and then ask. One of the other ways that I know some people are doing things is, add some anonymity here and there, and then have different AI bots do different parts of it so that no one bot has all the access to all the information. One of the other, and then you've got even the quality issue, right? So there are, in my experience, some really significant quality issues coming out of AI. I mean, I've poured a lot of effort into safely playing with some of the stuff and come to the conclusion that the quality just wasn't there anyway. But so I created some anonymity, I created some fake scenarios, some fake clients, put some data into AI, got a report back, and honestly, the end result to me was, well, I mean, I have something to react to, but this is absolute junk. And I did the academic things to make the tool good. That being said, there's a couple of AWI members out of California, and I'm sorry for forgetting their names and the name of the product, but they are making investigative specific tools. And my experience in this moment was that they just aren't user friendly enough. Like they're way too techy, way, way, way too techy still. But I love that people who are doing Title IX and Title VII and Title II work are hyper focused on an AI application for our investigative industry in particular, because I think once we figure this out, we'll be able to use that in hiring. But I also know the hiring industry is working on some really hyper focused information too. It's just that their security stuff is probably a notch down from what an investigative security standard is and would be and should be. Um, it's different, but maybe a little bit of a notch down. Um, and so like today, I can't say that y'all are doing it wrong by trying to avoid it. It's not good. And then Thomson Reuters, like inside of some of the legal tools, has some tools, but I go back to the quality just isn't there anyway. So I don't know. I don't know what the answer is for your organization, but maybe don't get too much heartburn because I'm not hearing that the output for anybody else is any better than what I've seen anyway.
Natalie, I would point out that I think you are talking almost exclusively about the like sort of analysis, synthesis, and report writing phase of
Fair
investigations. And I
enough.
agree with you that the tools aren't good enough yet anyway. So I wouldn't waste a ton of time trying to
Fair
get it
enough.
do your report writing for you. However, I do think these tools, with the caveats around anonymizing and using multiple different tools, can be really good for investigative tactical decisions around,
Right.
with this set of facts, who should I interview? With this set of facts, what questions should I ask? With this set of facts, what documentation should I try to run down? So I think it can be useful for investigative tactical decisions, but not, of course, overlaid with your human judgment, but maybe not at the synthesis, analysis, and report writing stage.
Well, and Lindsay, to your point, and Brian, I do see you trying to jump in. But Lindsay, like we've used it within our Westlaw portal with that security level for timelines forever. Like,
Right.
oh my God, we can save so many billable hours creating timelines quickly with citations. So I think you're making a really nuanced and but important point that some of the tactical stuff, the administrative stuff is probably great too. Like I can imagine Claude overlay and being, what is it? The Claude workspace, I'm forgetting what it's called, where it can go into your folder and just say, like, tell me all the people I interviewed, put it in this format on the report, like some of the just like robustly administrative activities, and use the word tactical.
You can find some efficiencies there.
Yeah, Colin, how do you react to that? I'm sorry, Brian, I keep cutting you off. Did
Are
you
you
want to add
good?
something?
Oh, I was gonna say, first step from my perspective is read the licensing agreement. And depending on the size of your organization, maybe you have some ability to negotiate that the AI doesn't train on your data and get some protections. And the other thing that I was going to say is, it's not the type of thing where you can put in a brief and put it in the reply brief and say, give me a response to that. But you know, with you reason and conversations with it and get it to explain its reasoning, there are some really creative and great uses. But yeah, please go ahead.
Yeah, those are really great thoughts. Thank you. So I work with one client right now that actually has its own private, and whether it's actually secure, that's not for me to say, but their own, private subscription with their own chat GPT service. So I've been able to experiment with that on behalf of the client. I'm just not able to use it within the rest of my organization. But within that experimentation, I have found some ways to use it for some of the things that Lindsay mentioned, just streamlining the efficiency, helping with summaries, taking a bunch of gobbledygook and making it make more sense, right?
Yeah.
But then on the analysis side, like you mentioned, uh, it
Smarter.
really depends on your prompt because you can put in the same set of facts and say, use this to write an analysis to explain why this does not rise to a policy violation. It'll give you exactly what you want, and it'll be a pretty slick looking analysis. But using that exact same set of facts, you can ask, use this information to explain why this is a policy violation, and it'll give you a convincing analysis. And so you have to know your stuff before you put in
Right.
the prompt,
Yeah.
and then
The
you have to know your
conclusion is
stuff.
still yours.
Yeah, you still have to know your stuff after you review it to make sure that it actually will hold water.
Yep.
Yeah, Colin, I make the joke a lot. You need a lawyer to write a lawyer prompt for AI. And I think you need to be an investigator who knows their project before you put in those prompts.
For sure.
All right.
AI will confidently give you a wrong answer.
That's right.
It's your job to know that it's wrong.
That's the thing. All right, guys, we're actually past time, but this one has been really good and lovely, and it was so nice to hear from Colin. But I will let everybody get back to their rest of their day.
Bye, everybody.